Welcome to MedMark's webinar series. Today's presentation is titled The mRNA and Lipid Nanoparticle Competitive and Litigation Landscape. I'm Sahal Reed, Senior Attorney in MedMark's Risk Management Department. On behalf of MedMark and today's presenter, Dan Shores, thank you for joining us. Dan is a partner at Rothwell Figg and is a founder of its Boston office. He is passionate about helping his clients build robust patent portfolios, litigate matters both as plaintiffs and defendants in the U.S. District Courts and in IPR and other post-grant proceedings, protect trade secrets, negotiate strategic collaborations, conduct due diligence and landscape investigations, and prepare for success in funding rounds and exits. Dan is a problem solver who excels at deciphering key translational aspects of a broad array of technologies to maximize leverage in the context of clients' desired implementation of such technologies, whether as participants in dynamic markets or as first movers. Dan is a registered patent attorney licensed to practice before the U.S. Patent and Trademark Office and is admitted to practice law in Massachusetts and in the District of Columbia. He is a member of the bars of the Supreme Court of the United States Court of Appeals for the Federal Circuit, and United States District Court for the District of Massachusetts. Dan lives in Boston with his wife Lindsay, their daughter Audrey, and their two English bulldogs, Jarvis and Rosie. And with that, I will turn it over to Dan.
Thank you very much, and it's great to be here. I really appreciate the opportunity that MedMark is providing, and so really looking forward to today's talk. Again, it's, the title is the mRNA and Lipid Nanoparticle Competitive and Litigation Landscape. We're going to get into, some details surrounding patent law but also this particular market, which I think is very interesting from a, non-patent perspective as well. And so I'm looking forward to talking about that with you today. You heard my background. My favorite part of that background, by the way, was that relating to my wife and our new daughter. Our daughter is going to be actually turn one tomorrow. So we're very excited about that. And obviously our bulldogs as well. But in any case, I've been practicing patent law for over 17 years, and including, during that time and focusing on the biotech space. I started my career as a litigator, and I still litigate cases, but I also have done a lot of counseling and strategy over the years, and in particular over the last few years, really in the last 3 or 4 years, particularly focused and built an expertise in the lipid nanoparticle and messenger RNA space. I think we all have a familiarity with that. At least I would think that folks know about that. That's really that technology underlies the existing commercialized vaccines from Pfizer, BioNTech, and Moderna. And we'll get into sort of that technology and how that technology applies in the market, and there's significant litigation. We'll get into all that. But in any case, for the last several years, myself and my team, our team have been focused on that particular space. And here are some exemplary members of our mRNA and lipid nanoparticle team. My colleague Aiden Harston, who's a partner in our DC office. I'm in Boston, and then our colleagues in Sheena Wang, Melissa Santos, and Andrew Staraska. There are a number of other folks from Rothwell Figg that are involved in the work that we do for mRNA and LNP clients, but this is just an exemplary list of our team. A great group of attorneys, scientists, engineers here, and just in great people as well. So, okay, so let's talk about the the sort of timeline. I highlight some of the timelines. Now, if anyone has ever been involved in a startup, whether it's in biotech or any other space, but a lot of times, but especially in biotech, you're sort of living on a dream in a way, and that's not to diminish the promise of what technologies each company might seek to realize. But if you don't have an approval, if there's no approval, if it's a novel technology, a novel biotech, but without an approval, there's a lot of risk involved. And that's not just on the folks that are on the front lines, that are in the trenches, the founders, for example, but that's also the investors and everyone else that is sort of involved in these startups. And when you talk about the founders, it's not just the founders, it's the founders' spouses, their kids, their families, and anyone that's been in the startup space knows that there's a lot of that goes in, a lot of blood, sweat, and tears that goes into sort of launching a new technology. Well, messenger RNA technology started just like that. There are companies that were involved in this technology, and the technology, we'll get into sort of how it works in a little bit. But there was back in this, I would just highlight that one of the pioneers in this space is a German company called CureVac, and they were founded in 2000. So over 20 years ago, CureVac started their journey in messenger RNA technology, and they are really one of the earliest pioneers. And then surrounded by a number of scientific discoveries relating to the technology. But CureVac put its stake in the sand about over 20 years ago. BioNTech was founded in 2008. So there's another pioneer that plays a significant role, as we'll get into, in the space currently. They were founded in 2008, really a startup company. And then not a few years later, and BioNTech is also located in Germany. A few years later, here in Boston, across the Charles River, a company called Moderna, which I'm sure you've heard of by now, was founded. They were also a startup company, and they were, engaged in the messenger RNA space. Over the course of this time, from 2000, when CureVac was founded, BioNTech, Moderna, these other players. By the way, there were other companies. This is not an exhaustive list of companies. I mean, there was a company called Translate Bio, which is also located in the Boston area, that was purchased by Sanofi a year or two ago. They were also an early pioneer. I mean, they came later than Moderna, but they were in the mix. But in any case, from between 2000 and 2019, you had companies, these pioneers. They were building up their portfolios. They're building up their patent portfolios on the innovations that they were developing. And then also they were building their pipelines. They were building their candidates, drug candidates, mRNA-based candidates that they were seeking approval for through the U.S. regulatory and other regulatory agencies throughout the world, wherever they wanted to enter the market. Obviously, the U.S. is a key market, so all those companies had pipelines and so up until 2019, Moderna had in the range of 20 plus mRNA-based drug candidates in the pipeline without approvals, no approvals. They were in the clinic, but they had not been. They had some candidates, I believe. I am pretty sure about that one. Is they had some candidates in the clinic, but there had been no approvals, and there had been no mRNA-based approval for Moderna or anybody else, and before 2019. CureVac had, I believe, it was in the teens, maybe like 15 or 20, 15. I'd say it's a range of 15. mRNA-based candidates in the pipeline. CureVac had a similar number. So you have these pioneers that are investing millions upon millions of dollars and research and 20 years of work, no approvals, and that's not uncommon. There are in terms of in biotech. I mean, you can identify any number of spaces today where folks are in a similar situation where there's no approvals. But along came the pandemic, and for all the tragedy that the pandemic caused, I think one of the concomitant positives was the ushering in of a new era of therapeutics, which is mRNA technology. mRNA technology, because of that technology, when the COVID-19 virus was identified and mapped and understood and knew the configuration of the virus. And through normal routes, a normal vaccine synthesis is you identify the virus, you kill the virus, or you grow the virus, in, for example, chicken eggs, and you amplify the virus, kill the virus, put that in a vaccine, and then inject into your body, and your immune system detects the dead virus and then builds its responses based on the dead virus. That process takes a long time. mRNA technology identified the COVID-19 virus, and then the folks at BioNTech and Moderna synthesized an mRNA sequence which could be delivered into the cell and had our cells produce the characteristic protein, which is the spike COVID-19 spike protein, and then you express the protein, and then that's how you train your immune response. Point being, because of the nature of the technology, Moderna and BioNTech were first in line. They had this synthesized almost immediately, and then went it before regulators, and then they were those candidates that they eventually went to FDA with, for example, were first in line, and then the rest is history, and you get the approval. So it's pretty amazing. I mean, you don't really see that, but for the pandemic, it ushered in this whole new era of therapeutics. And again, it's not just we're not just talking about we're not just talking about the COVID-19 vaccine. This technology has a wide range of applications beyond just obviously COVID, but infectious disease, oncology, rare disease. And so there's a lot of excitement around this space, and I think deservedly so. And so I think that's an important sort of context to kind of frame the discussion today. I'm a patent lawyer, as Zahal indicated, and as I indicated at the beginning. So there's going to be some patent stuff in here, and so there are certain different areas of patentable subject matter that arise from this technology. And here's sort of a broad brush overview. There's the cargo, the lipid nanoparticle. What type of, we'll talk about these in a second in more detail. What indication, what indication or what disease are you trying to address? There are certain qualities of these lipid nanoparticles that are important and that have potentially patentable subject matter. But for example, cellular targeting, I think, is a big one now that folks are focused on, and then also the route of administration. And so there's a lot of innovation that can be protected through patents, and that's something that certainly patent lawyers pay close attention to. If we were in a room full of patent lawyers, like, this slide would stay up a lot longer, but I just wanted to give you an indication of the types of areas where the patent law comes in to try to protect some of these innovations. Now, here is an exemplary lipid nanoparticle, and a lipid nanoparticle. We talked before about messenger RNA. Okay, so messenger RNA. Let's start there, and that's the cargo. Messenger RNA is essentially it's a sequence of nucleotides. Like RNA is like millions of nucleotides in length, and mRNA is shorter than that. I mean, I'm talking about oligonucleotides here a little bit, but in any case, there's sort of a modified or an engineered piece of RNA, of mRNA, and what the mRNA's job is. mRNA's job is, like, naturally in your cells, we have mRNA, and the mRNA's job is to help with the process of, it's like computer code. It tells your cell to produce a certain protein. So it programs your cell to produce, proteins that are useful for the tissues in your body. But here, what the science is, what the secret sauce is here, is that what you put into your cell is going to do. And so even though, like, when we talk about the spike protein, you can program what these innovators have done, and it applies across the board. You can program and configure the messenger RNA strand to tell your cell to produce a wide range of different proteins, even if those proteins are not naturally produced by your body. And so here, again, as I said before, the mRNA the sequence was programmed to go inside the cell and then tell your cell to produce the spike protein that appears in the coronavirus, so your immune system could recognize that. And even though your body would not normally do that, unless it was maybe infected by the virus, but even then, so it's really kind of a powerful technology because you can basically turn your cells into these sort of specialty protein factories and train your immune system in the case of infectious disease. So pretty powerful technology. So again, but that's what the cargo is. But the problem is you can't getting this, if you were just to inject this cargo, this mRNA sequence into your body, it's a fragile molecule. So your biochemistry would just obliterate that messenger RNA. So you need to, but your goal is to get it inside of a cell. So you need to protect that with something. And here, what scientists had developed over the years, and we talked about the mRNA pioneers. Well, there's a whole other set of lipid pioneers, lipid nanoparticle pioneers, and that will come a little bit later. There'll be a slide on that which shows the landscape. But you had you had this engineering challenge, and how are you going to get the molecule into the cell? Well, what scientists had developed over decades are lipid nanoparticles, and the lipid nanoparticle here, this is exemplary. This is a 4-component lipid nanoparticle, and the 4-component lipid nanoparticle contains 4 types of lipids. And so when I say 4-component, it has the lipids. The 5th component is the cargo, but the 4-component lipids, the 4 lipids in the lipid nanoparticle include a cationic lipid, which is shown to the left, a phospholipid, which is on the bottom, cholesterol, which is on the bottom, and then a conjugated lipid. And each one of these lipids, when they're put together in a certain way, they form, and it's not going to be a perfect circle. I think there have been some that have taken, electron SEM images of this, and but it's not. Think of it more sort of like a globule, and from what I've seen at least, and then encapsulated within that are these payloads, the mRNA sequences, and each one of these lipids, the cationic lipid, it has a positive charge when it's outside the body. When it's put inside the body, it goes neutral. When it goes inside the cell, it becomes positive. The phospholipid is in cholesterol are more for stabilization. Conjugated and PEG lipids also provide some stabilization, and they also assist with prolonged circulation of lipid nanoparticle in your body. But like all of these sort of together, and you can imagine that the maybe millions, I mean, certainly thousands upon thousands of different permutations of this probably were tried and scrapped, but eventually the scientists found a configuration that worked. Now there's other configurations that work, but the one that is being used in connection with the current the sort of current vaccines, they got that to work, and that's for the Moderna vaccine, Spikevax, and then the Pfizer BioNTech vaccine. They each use a 4-component lipid nanoparticle system to deliver the messenger RNA. And just to sort of finish this tech overview here, so this is what these lipid nanoparticles with the mRNA, like if anyone got the Moderna shot or the Pfizer shot, that's what is in the shot. And there's probably millions of these that gets inserted into your body, injected into your body, into your muscle, into your shoulder, and then it distributes and it finds. So this lipid nanoparticle not only protects the mRNA, but when it finds a cell, when it comes in contact with a cell, it reacts with the cell such that the cell takes it in. The cell will take in the lipid nanoparticle, and the lipid nanoparticle will open up, and then the messenger RNA will deliver inside the cell, into the cytoplasm of the cell. And really pretty amazing, engineering feat that you could actually deliver the mRNA in this manner. Pretty amazing. And there's a lot of chemistry involved in the charges inside the cell. There are endosomes, and you had to have endosomal escape so that the mRNA sequence can can survive and doesn't itself get destroyed while it's in the cell. So again, pretty amazing. But that's a tech overview. Again, with sort of patents data, you can see that there's been a lot of filings, especially over the last several years. I mean, this is a 5-year range. The filings probably would have, post-COVID, would have increased around 2019 to 2020, and so you sort of see this. It's a little bit of a rudimentary graph here, but you can see what companies are seeking protection on. And certainly the lipid nanoparticle, that's the top line there. I mean, folks are seeking protection around the whole nanoparticle, which includes the formulation of the different types of lipids that are involved. And then also engineering of the payload. These payloads are modified, like the ones that are in the Moderna and Pfizer / BioNTech vaccines are modified RNA. It means they were engineered, and partly, certainly we talked about writing them to sequence the spike protein, but there was also a modification to the nucleotides within there. And instead of using uridine, there was a synthetic called pseudouridine that is used in the mRNA sequence. And that was a development that was created by the professor, Dr. Carrico and Drs. Carrico and Weissman at the University of Pennsylvania years ago. And that was important because using the pseudouridine caused it was less offensive to the immune system. They did studies where using just natural uridine was caused an immune response in I believe it was rats in their studies. But then when they modified the mRNA to use pseudouridine, then that was avoided. That immune response was avoided. And so that technology is currently in the current vaccines. And so there's a lot of, if you come up with something new and for patenting, if it's new and it's not obvious, then you can apply for and obtain a patent on that technology. And then you can see here on the blue line, folks are seeking protection on the actual payload, the sequence itself. Also, the cationic lipid itself, like each one of those components, we talked about the 4 lipids, not cholesterol or certainly not cholesterol, because that's out there, right? But like phospholipid, not that either, not as much. But the ionizable lipid, the charged lipid, and then the conjugated lipid, those are engineered. Those are synthetic, oftentimes man-made lipids. And so when you seek patent protection, you can get a patent on the lipids themselves, also on how they're used in their formulation, but the structure itself, you can seek and obtain patent protection on. And so this chart here shows the trend and what these folks that are in this space are seeking and obtaining patent protection on. And here are some of the the sort of key players, and shows their total patent filings. We talked about several of these: CureVac, Moderna, BioNTech, Translate Bio, and then we touched on some of the lipid pioneers, which are Arbutus and Alnylam. And Alnylam is not just a lipid pioneer; they also have a commercial product that's not in the mRNA space, but they used liposomes on Patra as their product, but it's not an mRNA-based product. In any case, I believe it's an siRNA-based product. In any case, and then Acuitas is another lipid pioneer that you see that they're also engaged in this space. Okay, so usually my drum roll is here is we talked a lot about this, and the fact is that it's complicated. The relationship between the relationships between the companies is complicated. What I tried to do here, and I've published on this, really over the last 2.5 years, and I update it as often as I can. Although I'm not sure how much up to date this one is. I'm sorry to admit that. Changes so fast, but this gives you a sense, an idea of sort of the interrelationship between the players in the space. And so here we just to do a flyover here, we have CureVac, again, German company in the upper right, founded in 2000. BioNTech in the lower section, they were founded in 2008. Moderna, upper left, founded in 2010. I'd say those are the sort of key pioneers. Translate Bio was another pioneer. They were acquired by Sanofi a few years ago. Those are the mRNA pioneers. Alnylam is a lipid, but again, they also have a commercial product and that is not mRNA based, but that uses their lipid technology. They have a very large lipid patent portfolio. Arbutus is a longstanding pioneer in the lipid space, and they have a significant lipid patent portfolio. Acuitas, another longstanding pioneer in the lipid nanoparticle space. They also have a significant patent portfolio. And then CellScript UPenn, we talked about. That is the CellScript is the company that sublicenses the Carico and Weissman modified mRNA technology from the University of Pennsylvania. They license that technology to Moderna and BioNTech, and then we have these other companies, Etherna, Arcturus, Geneva, these emerging companies located. The emerging companies are now entering the market and with increasing rate, as you can imagine, and because of the promise of the technology. I mean, these giant companies, the pioneers, the pioneers, Moderna, BioNTech, and CureVac, really, but CureVac, by the way, unfortunately didn't have an approval. I think they were in line. It's not known why their technology didn't work as well in the clinic. Like when you looked at Moderna and BioNTech, when they came through with their vaccines, there were reports of 94 to 95% efficacy in a vaccine, which is unbelievable. I mean, a regular vaccine, and like we talked about, the ones where you grow and kill the virus and make it into a vaccine, their efficacy was in the 70s, ranging in the 70s and 75% or something like that. 74, 75% efficacy was considered to be good. That was sort of like the standard. But when Moderna and BioNTech, new technology, and then to come out with 94 to 95% efficacy, it was a home run for the technology, but also obviously those companies as well. When CureVac developed its vaccine and was developing it in the clinic, CureVac efficacy was in the below 50, I believe. It was like 47% or something like that, which I would imagine was very disappointing for those at CureVac. And there's a lot of innovators that work at CureVac, and again, they're one of the really earliest major pioneer out there. And so I think they likely were not happy about that, and for good reason. And but hey, in the course of a company's life cycle, you're going to experience highs and lows, but one thing that some commentators have pointed out, that CureVac did not use the modified mRNA that Moderna and BioNTech use, that's licensed from CellScript and UPenn, the Dr. Carico technology. CureVac used, my understanding is they was unmodified, which would be more just uridine and as in the nucleobases of its payload, but whether scientifically that means that's why it wasn't effective, I don't think there's been any study on that, and I don't think anyone could conclude that. I mean, there's a lot of other variables involved, but in any case, that was that's sort of how that played out, and and again, you have all these startup companies that are entering. I mean, like so Moderna and BioNTech, and Sanofi now has a Center for mRNA Excellence. Those companies, they're shooting for the moon here. I mean, in their oncology programs, some major disease, malaria, and which is incredible. I mean, to the extent that this technology can be used to treat and to move the ball forward and treating some of these major human diseases. I mean, that's incredible. And will it happen? I mean, I think that remains to be seen. That remains to be seen as to how broad and effective the applicability of this technology really is. But it why hold back? I mean, I think it'd be amazing to see what can be done with this technology. In the meanwhile, those companies cannot possibly cover the landscape in terms of the different indications that can be addressed with this technology. And therefore, on comes the role of the startup companies, the new startup companies that enter the space and find niche areas where this technology can potentially be realized, and that the pioneers are not focused on. And I think that's a very healthy ecosystem for this space, is that type of dynamic, because then you've got economic motivation by a lot of different types of entities. And so I think it's exciting. I think it's exciting. Now, again, I started my career as a litigator, and so this is not, to me, it's standard blocking and tackling, that once products are sold and folks are, companies are making money off of the sale of those products, that other entities that own patents, that have patents to technology that they think is being used in connection with those commercialization efforts, you're going to see patent infringement. There is going to be a patent infringement action. Doesn't always start off as patent infringement. A lot of times it's, hey, you're using our technology and we have a patent. We don't want to sue you. We don't want to go down that road necessarily. But will you take a license from us? Sometimes it's not as a nice message as that. I mean, but it should be. And you don't want to assume that that someone's not going to want to take a license to your technology, especially if your technology legitimately covers what the other entity is doing, what they're doing, what they're selling. And so we talked about the timeline a little bit. So 2019 we had COVID-19, right, and into 2020. All throughout 2020, you had the approvals, right? You had the warp speed approval process, which, again, even that, I mean, we talked about the nature of the technology and that Moderna and BioNTech were first in line and they got to move forward. Well, there was a whole other set of processes after that where, under Operation Warp Speed in the US and other, there are rapid approvals in other areas in Europe and other areas as well, but just focus on the US, you saw pretty unbelievable that how quickly these drugs were approved. They were approved within a year. It was December 2021, 2020, excuse me, that these drugs were approved for emergency use authorization. And anyone that's in the biotech space knows that it doesn't take a year to get a new drug approved. I mean, it takes years, sometimes decades. I mean, so that in itself was amazing. Now, of course, you had they had the emergency, right? We had the pandemic, and so there, putting pressure on regulators to provide an approval, I think, made a lot of sense. I'm just saying it was amazing that those drugs were approved so quickly. And I think Dr. Fauci came out and said, "Look, it's going to take years." I think that's one of the first things he said, and he, but that didn't prove true in the sense that that these drugs were approved, and then we're just the widespread use of these drugs over the following year. I think it's $40 billion, $40 to $50 billion in combined sales. Between Pfizer, BioNTech. Pfizer and BioNTech has the technology, but Pfizer is their commercialization. So they have a partnership. So they're sort of one entity for this purpose of this. And then Moderna, I mean, tens upon tens of $billions in sales of products following those approvals. And again, going back to, when others see or when others know, or maybe it's not just them waking up one day and saying, "Oh, you're selling our technology." These companies, or you're using our technology. These companies, like certainly Arbutus did. There's a history there, but these other companies saw what was going on and said, "Well, we believe you're using our technology." And then, so in 2022, so over the course of 2021, you had these sales and the use of the vaccine. Moderna did a patent pledge. It was sort of kumbaya in a way, where no one was suing anybody. And Moderna said, "We're not going to sue anybody on our patents for the term of the pandemic. And we will license with you, but we won't sue anybody." In which they pulled the plug on that after they were sued. But in 2022, as of February 2022, and here's the litigation landscape. As of February 28th or February 27th, so day before this, 2022, there were no lawsuits. There were no patent infringement lawsuits, major patent. I mean, I think there was one minor suit that was filed, but it wasn't really involved with this. But there was really all was quiet. Everyone was moving forward. Then on February 28th, 2022, Arbutus, who is a lipid pioneer, sued Moderna for patent infringement on 6 of its lipid nanoparticle based patents and accused Moderna of using its technology. There's a history here, as I indicated before, where Arbutus had actually, sought a license or went through that dance with Moderna previously about taking a license and we have these patents and we think you're using our lipid nanoparticles. Well, Moderna tried to cancel 3 of Arbutus's patents, and you can do that at the USPTO through what's called an inter-party review proceeding. And what you do is you put a petition together and file it with the USPTO and allege, based on the prior art, their patent's not valid. So Moderna tried to scuttle some of these key Arbutus patents at the USPTO. And Moderna was successful during that process. This all predated this. This predated the pandemic. They filed, I think, in 2018. In any case, Moderna was successful at canceling one of Arbutus's patents, was split the other one, meaning there were some claims of the second Arbutus patent that were canceled, but other claims in that patent that survived. And then the third patent survived altogether, a patent called the 069 patent. So what Arbutus did was, they filed a lawsuit. They eventually, declared that the parties weren't able to come to an agreement. And, they filed a lawsuit. And in patent infringement, the damages, there are different types of damages that you can get in patent infringement. One of them is a reasonable royalty, and the other is lost profits. Lost profits applies usually in the direct competitor situation, where you can say, but for your sale, I would have made the sale, for example. This wasn't a direct competitor situation. So what the damages that Arbutus is seeking from Moderna is called a reasonable royalty, which is the courts have this construct where there's a hypothetical negotiation. They create this hypothetical negotiation between, if the negotiation had ever happened between Arbutus and Moderna, what would the terms have been? And then the analysis, and the parties have experts, and the analysis comes out with a certain royalty rate. Well, even assuming that the royalty rate here would turn out to be 5%, which is maybe low for biotech, depends on type of technology. 5% of $20 billion or $30 billion is a significant amount of money. And so, there's a lot at stake there in terms of total values for Arbutus and also for Moderna. Well, so they filed that, Arbutus filed that lawsuit. Not long after that, Alnylam on March 17th, 2022. So a couple weeks later, 2-3 weeks later, Alnylam sued Moderna and BioNTech and Pfizer and BioNTech, maybe not initially, but eventually they got pulled in for patent infringement. So Alnylam is asserting its patents. Same damages, exposure, reasonable royalty for each of those lawsuits. Alnylam had some applications that it filed and got patents for. It went out and filed a lawsuit against Moderna and Pfizer, and those technologies relate to the lipid technology. Arbutus's lawsuit related to the lipid technology, but mostly the formulation of it, the percentages of each of the lipids that's used in the lipid nanoparticle, where Alnylam had specific ionizable lipids that it had patents on, and so it asserted those against Pfizer and Moderna. Acuitas, a day later, Acuitas filed a lawsuit against another lipid pioneer, filed a lawsuit against Arbutus and Genevant for declaratory judgment of non-infringement and also invalidity. That case is interesting. Acuitas does not sell products that sell any commercial products. It's not clear what the motive is there. We know that Acuitas has a partnership with Pfizer and BioNTech, but this is all public information. None of these folks are our clients, and so this is all public information. Not clear what the motive was, but they did file a lawsuit in the Southern District of New York. There was a question of whether Acuitas had standing. Ultimately, recently, actually, Acuitas voluntarily moved to dismiss that matter and then refiled in the District of New Jersey. So you can pull the plug on a district court case if the other side hasn't responded. So that's the procedurally sort of with that. So that's an active litigation, Acuitas versus Arbutus and Genevant. And so, sort of it sort of went on. CureVac filed a lawsuit in July of 2022 against Pfizer and BioNTech in Germany, saying that Pfizer and BioNTech are using its technology. Pfizer and BioNTech then turned around and sued CureVac in the District of Massachusetts, saying that it doesn't infringe CureVac's technology and that CureVac's technology is not valid. Actually, just non-infringement. They don't infringe, and that case was transferred to the Eastern District of Virginia. You had then, and this was sort of interesting, is that if you look at the sort of what's happening here, the two entities that are generating revenue from the sales of products, there's Moderna and then the Pfizer BioNTech groups. So that's where again, and this has all been reasonable royalty up until August of 2022, all reasonable royalty. And by the way, the one thing I should have mentioned, and I will now, is that another remedy that you can get when you're accusing somebody, or you can seek when you're accusing somebody of patent infringement, is an injunction. And what that means is that you tell the court, they're infringing, I want an order, or we're requesting an order to tell them to stop doing something, which is very powerful, can be very powerful, even more so than damages, when you can get somebody to stop doing something and through order of the court. Now here, there are no injunctions being sought. And I think there's good legal reason for that, because a lot of these aren't direct competitors, but there's also a good practical reason for not even seeking doing that, because who would want to be the party that's asking Moderna and Pfizer BioNTech to stop selling needed vaccines? I mean, there's good legal reasons. as well as practical and public relations reasons as to why no one was seeking an injunction. So in August of 2022, so at August 25th, 2022, August 25th, 2022, you had all of this activity, reasonable royalty. Pfizer and BioNTech is exposed to reasonable royalties from Alnylam, Arbutus, Genevant, potentially CureVac in Germany, maybe in the US, depending on how that case goes. Moderna gets exposure from Arbutus and Genevant, and then also Alnylam. Well, on August 26, 2022, Moderna sued Pfizer and BioNTech, and they sued them for patent infringement. So Moderna has patents too. I mean, Pfizer, BioNTech has patents too. And so Moderna sued Pfizer, BioNTech for patent infringement, and they sought a reasonable royalty, but they also sought lost profits, which is, but for your sale, I would have made that, which can be, depending on the facts, can be a significant exposure, or you could yield more damages potentially through that theory. But it just didn't. But they could assert it. I think that's also part of it, is that they had the ability to assert it because it was that lost profits, because it was a direct competitor situation. And so that's kind of like the state of play. Like, again, this happened, all that activity, and I haven't talked about chromosome yet, but all that activity happened from February 28th until, it was really 6-month period, August 26th, 2022. Just so, like, again, that's not surprising to me that this happened, especially with the numbers involved, especially with all the pioneers. But I think, and I've served on some panels, other panels, and it gets mixed reviews as sort of like a look for the industry, which I can appreciate. I mean, IP is under attack all the time, and to me, a lot of times unjustifiably so. But since this is such a high profile technology and such a high profile market, it's then the fighting, quote unquote, is more high profile, and so it is what it is. I mean, I think the way this will shake out is either through the merits of the cases and or through settlement. For example, in going through the dockets today, I sort of caught up a little bit on what's been happening. I have a day job. I'm very busy right now, but I did catch up on the dockets, and one of the sort of key outcomes of the last few months is on August 30th, Moderna won a final judgment of non-infringement. And in these patent cases, the parties will go through what's called claim construction, and then during claim construction, find out what the meaning of the claim is and what the court rules and what the meaning is, and then you apply that against the accused product. And if it's a clear definition and the accused product doesn't have one of the components in the claim, then it's non-infringement. Apparently that's what happened here. So the parties actually seemed like they agreed to a final judgment of non-infringement, and now that's on appeal to the U.S. Court of Appeals, to the Federal Circuit, and probably to review the claim construction ruling. And so that's on appeal, but there was a final judgment there. We talked about the update with Acuitas, how they now like rebooted their case, and they can only do that once, by the way. I mean, they are able to reboot their case in a new jurisdiction. And then in the CureVac and Pfizer BioNTech US case, there was a transfer of the case from the District of Mass to the Eastern District of Virginia. So that case is now pending in Eastern District of Virginia. Okay, one of the things, Chromosome sued Moderna and Pfizer BioNTech for their technology, which are, one mRNA-based method patent. It looks like that case was voluntarily dismissed by Chromosome against Moderna. It's still pending. I believe it's still pending against Pfizer and BioNTech, but that's the sort of state of play here. I think for anyone operating the space, you want to monitor what's going on. But again, we're not going to know if these go through all the way through trial. These can take years, years and years, and then up through appeals. You're looking at 3-4 years, maybe even more. And oh, by the way, so we talked about Moderna suing Pfizer and BioNTech. Well, another very recently, I mean within the last month, Pfizer and BioNTech filed 2 IPRs, which we talked about earlier. You can try to cancel patents. So it looks like there's 2 of the 3, I would assume. I didn't go into the docket of the IPR, but 2 of the 3 patents probably that are being asserted by Moderna against Pfizer and BioNTech are being challenged. Pfizer and BioNTech are challenging those patents. And if they are successful challenging the patents in the IPR, then the patents go away, and then the case goes away, and then their exposure goes away. So we'll have to see how that plays out. And you never know, these parties can settle. And if they settle, so for example, if Pfizer and Moderna settle, then there'll very likely be no there'll be no issue relating to final judgment, and so but everyone's patents will likely stay intact, and so anyone operating in the space will have to keep an eye on those patents. And that's in particular importance with this Moderna Arbutus case, because the Arbutus patents, some of them are fairly broad, and one of them, the 069, survived the IPR that we talked about earlier. And if it survives this case, I mean, it's something to be aware of. A lot of these patents, though, a number of them are coming up on expiration. So you want to, you can navigate here. And if, again, I don't know if anyone on this call is in this space, but if you are, just consult with your patent counsel, if you're operating this space, relating to the landscape. Looks like I'm coming up on time. I've got more slides, but I've talked about a lot of this. So you had, and I want to leave some time for questions. So I'll just try to do this in like 30 seconds. This slide, and you can look at it if you want later, indicates the technology that are issued in each of the cases. And then here's sort of like a strategy slide. For you to operate, understand the landscape, know what your commercial product is, set a strategy to launch in the landscape, understand the timelines involved, do the work before you develop, because it's expensive to go down a regulatory road and then realize that you're screwed, excuse my language, with patents. Like, you really want to figure that out early. You want to, then there's also opportunity for innovation. If you're designing around a product or developing something new, you want to build your own assets and your own technology so that you can license it to others and sort of build around what your niche is in the space. Licensing, innovation. No, we already talked about that mostly. Licensing, you want to choose your partners wisely. I mean, that's just like good old common sense. You've got, there's a little strategy that surrounds all of it. The IP and regulatory. What are you doing in the clinic? Is that something that can be patentable? And then, what's your strategy? Like, if you're concerned about a regulatory path of one product, well, maybe start with something that's going to get you on base, and then pursue that, and then have, work on your more challenging ones and later in the pipeline. And then we talked about the PGI. If something's in your way, you can file an IPR. There's also a PGR. You could file that within a year of patent grant, but you can file an IPR and try to clear the path for, if you think a patent, you want to have good grounds, and you want to have some good prior art, for example. If you do, then you can try to clear the path. Some other folks might thank you if you do that too, by the way. And then district court litigation. If you're a patent holder, don't be shy to assert your rights. And then but you also may be on the receiving end of that. And you just have to, pay close attention. So I'm going to stop there, open it up for some questions. I think I left about 5 minutes on the clock here.
Yes, thank you. We do have a couple of questions for you from our listeners. The first one, please explain some of the differences and nuances between patentability of messenger RNA versus modified RNA elements.
Yeah, so I think we talked about that earlier. I think you have messenger RNA, you have mRNA, and if you take the examples of CureVac has an mRNA sequence, but it's not modified. The mRNA is going to be comprised of nucleotide building blocks, And then each one of those nucleotide building blocks will have bases, different bases, cytosine, guanine, bases attached to them. And so you have naturally occurring RNA, but if you engineer the sequence, either rearrange them, use different monomers like 2' fluoro, and it creates something that's not found in nature. So that's not found in nature. Then that's a patentable event. That's a modified RNA, and then that becomes a patentable event. We also talked about the pseudouridine, which is uridine is a naturally occurring base, but that was engineered, and so that would also be modified. And so there's anytime that you change something. Like the patentable subject matter is anything, the famous Supreme Court quote, anything under the sun made by man is patentable subject matter. So if you alter something that something natural like RNA, like an RNA, but you alter that and man comes in and makes the alteration, that's a patentable event. That's something that's new. You'd have to argue it's not obvious, and then you can get patent protection around that.
All right, thank you. And I think this is a follow-up question to that. What kinds of licensing terms can be expected?
Yeah, that's a great question. So if it depends, right? It depends on what you're trying to license first, right? So and when you're talking about if you're going to in-license patents that relate to lipid nanoparticles, for example, and so you're across the table from a lipid pioneer who's seeking to license their technology, you're going to, number one, realize immediately that that they're in demand. The other side, that lipid pioneer is probably going to have set terms, a lot of non-negotiable terms. And I think part of that too is if any of those lipid pioneers are involved in a litigation, they're not going to want to come down because that can affect what their damages projections might be for existing case, because that's all sort of evidence. I mean that's. But in any case, putting that aside, you would want to expect that that there are going to be some terms that they're going to have their price, and not all lipid pioneers or anybody really. It just depends. I mean, but they're going to have a significant amount of leverage, depending. But you may have leverage too. So again, it's kind of an old, ambiguous question in the sense you don't really know what the parameters of the potential deal are, but you can expect that. And then also in terms of the field, and I think, well, you have success if you're operating in the space. You're going to want a specific, like if you have a specific indication or a specific product, that if you developed a novel payload, for example, you may get a narrow exclusive license, depending on who your partner is, to commercialize that specific payload. And then sometimes what these lipid pioneers will do is they'll sort of help you with the lipid formulation. And so you license not only their patents, but their know-how. But it all depends. It really depends on, it really depends on the situation. And so I hope that answers that question.
Yes, thank you. We do have one last question. Could you please comment on competition landscape of current capping technologies such as ARCA, Cap0, Cap1, CleanCap, et cetera?
Sorry, but I'm not sure I'm familiar with, or I didn't hear it correctly. I'm not sure I'm familiar with I'm not understanding the question, I guess.
Okay. I think it might be a niche question about a specific area or technology.
Yeah. If anyone has any questions, like wants to reach out to me, feel free to reach out and we can set some time to talk about it. I'm happy to answer questions because I think I know what that is, but I don't want to answer because I want more information. And if that person wants to reach out to me, they're more than welcome to.
Okay. Wonderful. Well, Dan, thank you very much for your time today. More than ever in this new therapeutics era, we found ourselves in companies are striving to develop more mRNA-based products while tackling the accompanying patent issues. So we really appreciate your ability to break this complicated issue down for our viewers.
And thank you once again for having me, and really enjoyed it.